on today's episode of Retrial Podcast.
I'm making the opening statement on behalf of the Mead Corporation. And as I look up at Judge Rubin and I hear this murmuring behind me, I look down and there in the bay of this big courtroom, there is a cockroach that is quietly walking from one end of the courtroom to the other end of the courtroom on a nice diagonal path. And to that cockroach, this case meant absolutely nothing.
Not at all.
And I'm thinking, well, you need that to kind of put it all in perspective.
Welcome back, Retrial Podcast. You ready to do this again?
I think so. Why not?
Hey, we are here decoding legal history that happened in Dayton, Ohio. These cases, lawyers, and stories set the stage for present-day learning across our nation. Hosted by myself, Judge Gerald Parker, trial attorney, the great historian David Greer.
I hope I can remember some of that stuff.
Yeah, please do. So in this episode of Retrial Podcast, we'll be taking a look at the concept of corporate greed, mergers, acquisitions, a major case in Dayton history that was considered a hostile takeover, and kind of, I'll be honest with you, Dave, I wasn't looking forward to this episode.
Oh, man. This
sorry, I
is
wasn't.
great stuff.
I wasn't.
I mean, it's like seduction versus rape. What is more exciting than that?
Wow, we're starting off pretty
Yeah.
hot and heavy.
It used to be if you wanted to, I think I like your business and I'd like to have it. Let's just have a nice talk about it. It'd be good for both of us, right?
I think yeah, absolutely.
You make some more money, I'll make some more money. Well, I'll be happy.
Yeah.
Because money makes people happy, doesn't it?
Right.
Yes. So let's do that.
Okay.
So somebody says that's a good idea. But what if the person you're talking to says, oh, no, I'm happy doing what I'm doing, and I don't want to be messing around with you.
Yeah.
That's the story we got today to tell. That's a pretty good story.
It's almost like the big fish eating the little fish type
It
scenario.
is. Goes all the way back to that old, 15th or 16th century painting of the big fish eating the little fish, because that's the way the world works.
Yeah, that's good.
The little fish all get gobbled up.
And we're seeing it happen even within law firms, right? The larger big name law firms are gobbling up the mid-level firms, and now we're seeing that all over the place.
Used to be you dealt with a lawyer as a single human being or one of a small group of people. Now, whoa!
And then we'll take it over to, the reason why I really wasn't looking forward to this, one, I thought it might be boring. I didn't think that it would have much applicability to now. And then apparently the Supreme Court just threw us yet again. I think we had the Dobbs decision came out when we did the abortion cases on that episode recently. And then the most recent decision that just came out that has an impact on kind of how we've been doing things for the past 40 so years.
The Supreme Court has really done a great job of giving people things to think
about.
They
knew
anyway.
we were doing this podcast,
right.
and they were like, hey, let's make some decisions so that retrial would have something to talk about. So I thank you to the Supreme Court.
It's kind of a dubious thank you, but what the heck.
I agree. So how do you want to start? Do you want to do a little timeline here? Do you want to just discuss kind of what Mead is? Yeah, what are your thoughts?
Well, give us a little background on the Mead Corporation, then I'll give you a little background on how this thing built up into the hostile takeover that was attempted.
Gotcha. So the Mead Corporation, founded 1846 by the only Colonel Deeds, right? Colonel, is that right?
Yeah.
No, I'm wrong. Colonel Mead.
Mead.
I'm used to Deed because we've talked about Deed before, Deeds, and now it's Colonel Mead. My apologies. Daniel Mead died in 1891, one of the largest paper producers in the country, with paper mills in Tennessee, Georgia, Michigan, of course, several in Ohio. In 1957, it acquired the Atlanta Paper Company. I've seen those trucks still around, I think. The Atlanta Paper Company entered the packaging business and invented the 6-pack paperboard carrier for bottled beverages. Are you familiar with the 6-pack paperboard carrier for bottled beverages?
I'm not only familiar with it, I tried a patent case down in Atlanta, Georgia, they had people who did nothing but slice cardboard to see how thin you could make it and still pick up a 6-pack of beer and not have the whole thing splat out on the floor. Believe it or not, that became a
bad drinking game? It sounds like a bad drinking game.
It became an intellectual property fight between Mead and a competitor of Mead's that went through a trial in Atlanta, Georgia. I had my client, or my expert, was the head of the patent office for years, which turned out to be a job that really doesn't require any knowledge about patents. It's an administrative job.
Yeah.
Terrible expert. But
well, look, so in 1968, this is where it kind of starts to get a little spicy. 1968, Mead acquires Data Corporation, and soon their focus became information retrieval product in development. And in 1973, Mead Data Central launched Lexis Legal Research Program. I'm assuming at least research system, so I'm assuming LexisNexis curtailed from there. And then in 1994, I believe Mead sells LexisNexis system to Reed Elsevier for $1.5 billion. A lot of
well, that's way after our story, though. Yeah.
But there's a theme about this freedom to contract, to do business with people that you want to do business lurking in the midst. Mead expands other products by purchasing Woodward, an iron casting and rubber products manufacturer, 1968. Pipe valve fittings company, 1977, and then 1977, Mead sales of $2.8 billion, income of $98 million, and assets of $1.4 billion. I say all that because Mead is a fairly large vehicle in this.
Well, billions, what the heck? Everything is relative, and we talk about that. Sounds like a big fish.
Right. Well, how does that relate to
Dayton? In Dayton, we thought it was a big fish, but Occidental Petroleum was 10 times bigger. I mean, it swallowed like it was a sardine, or at least that's what it thought and what it wanted to do. The paper business became obviously good business for Mead. And they had a big plant down in Chillicothe. You could, within 5 miles of that plant, suddenly the aroma of the air changed magically.
Yeah.
And you thought you were in a kitchen where they're making cabbage rolls. Everybody thought, wow, Chillicothe is is that an Indian word for bad smell? Like Chicago was an Indian word for bad smell. And they said, no, man, that's what money smells like. So Mead was doing pretty well, but everything else in Dayton was kind of going to the dogs in the 1970s, which gets us into the framework of this hostile takeover that's today's subject. NCR was the big fish in Dayton for a long time. Early 1970s, it's getting rid of like 15,000 employees. I mean, suddenly the old mechanical cash registers are not the thing. The world of the computer is slithering in, much to the dismay of those of us. By the way, I just moved my law office, and we sent to the dump 2 tons of books. Books are irrelevant. Nobody uses them anymore. Yeah. And this was the start of that. Actually, the first computer in Dayton in a law office was a single lawyer named Emanuel Nadlin. And he had a little office over on Main Street, South Main building, little tiny building. And the computer filled his entire office. It was one of the early things that just this gigantic dinosaur of a thing. And the old guy who was the claims man for the local bus company came up to his office one day, and Mr. Nadlin said, well, look at this. This is taking over the world. This is going to change everything. And I put information into it, and then it gives it back to me as I need it. And we've got that case of Alice Jones against your bus company. And I know that the statute of limitations coming up in a couple of weeks. All I got to do is push this button, this little thing prints out, and it tells me exactly what the filing date has to be. So he said, oh, is that right? So he pushed the little button, and out comes the printer, and it shows that the filing date was last Tuesday.
That's a problem.
And the old man who's in his faded blue suit, who's the claims agent, reaches in his pocket and he pulls out one of those little spiral notebooks and he looks in it and says, "Oh, that's right, the statue did run last Tuesday. That's a pretty good machine." The machine kind of ramped up from there.
Of course.
And Mead got to be big enough that it could get into other businesses as well.
Right.
So it became a kind of a tasty fish in the fish market of mergers and acquisitions. But from the city's perspective, it was taking the place of NCR as the leading corporate citizen in Dayton, Ohio. In the 70s, we'd have plant closings.
Yeah.
We talked about NCR kind of ramping down to almost nothing. We had the desegregation litigation that was going on that was killing things.
Right.
And we were trying to build the city back up from what was turning into another one of those Rust Belt disasters. Yeah. And so here came Mead. The Kettering Tower was built in, 1971 or something like that. Then we had Courthouse Square built in the mid-'70s, Sinclair College in the early '70s. And finally, in 1976, the Mead Tower was erected, 1976. And just after they had put the word Mead on the top of the tower, where later Key Bank was and now is essentially an empty office building, but it was a big deal in that day. Here's Mead with 1,500 Dayton employees, along with all these other places elsewhere, looking pretty good. And it's going to be the salvation of Dayton. And all of a sudden, in comes this pirate ship. And it's this Occidental Petroleum going to kidnap the Dayton's leading corporate citizen. It looked like trouble brewing. Now, tell us a little bit about what that pirate ship contained.
Wow. Well, as you stated, we're around 1978, around that time frame. Mead, of course, is Dayton's leading corporate citizen. Of course, the folks are fearing that if Dayton gets gobbled up and gone, then it just decimates the town, the community of Dayton, and all that it's created. So then on August 10th, 1978, I got to make sure I'm saying this right because I still believe you guys are playing a huge prank on me. Armand Hammer, the CEO of Occidental Petroleum, offers Mead shareholders an offer valued at $980 million. He thought that they could not resist. First off, $980 million is a lot of money. Second, his name was Armand Hammer. That was his name, Armand Hammer. The baking soda Armand Hammer.
No.
This guy's named after baking soda.
There's a story that goes, on the Mead side of the equation, there were two major firms that did backup for him in the war that then erupted. They used the Skadden Arps firm in New York on the security side of the case. They used a firm called Howry & Simon from Washington on the other side of the case, which was an antitrust side of the case. Joe Flom was the big guy at Skadden Arps in the day. And when he's assigned this legal task, he calls, and this is a true story, like everything else we ever say. He calls a young associate into his office and he says, "I want everything you can find on Armand Hammer," because Armand Hammer was well known as being this international bandit who had made zillions of dollars and done it in ways that might not always smell as good as the Chillicothe plant of Mead. "I want you to bring everything that you can find on Armand Hammer and get it to me in a week and meet me right here in my office." And a week later, the kid comes in and he's got a little thin thing of paper. He says, "Is that all you could find?" He says, "Well, that little baking soda company doesn't seem to get into a lot of trouble." He says, "I didn't say Arm and Hammer. I said Armand Hammer."
Right.
And there's quite a difference there.
There's a huge difference there.
No baking soda involved in this game.
Right.
But that was one of many little stories that blossomed out of the litigation. Now,
I want to stop you right there, because when I think about money being offered and the typical, I'm going to make you an offer you can't refuse, right? That's what's happening here, right? This seems like, and particularly at that time, a lot of money that most would say, let's just take this money and go. But things got a little different from there.
they got different from there because while God knows how many shareholders there were
Right.
that would reap some money out of the deal if it went forward, there was also a business that was being run, and a business that had not only thrived and prospered, but had a bunch of people that it was the bread and butter for. It was the corporate conscience of had several people that were involved in the running of that business who fell in love with the concept of the corporate conscience, that corporations have a duty to do something for their communities and that sort of thing, and for their employees, not just money for their shareholders. So Mead says, no, I don't want to do it. And there became two ways of trying to defend against the hostile takeover, which was going to be a big offer to the shareholders that if they cashed in on Arm & Hammer would end up in his corporation, Occidental, owning the Mead Corporation, the big fish swallowing the little fish. There's not so little fish. The two paths to challenging a hostile takeover and saying, no, I'm not going to be seduced, I'm not going to be raped, either one. One was the securities path, that, hey, you've done terrible things and you shouldn't be permitted to grab onto this business. Problem, that was where Skadden-Arps did the backup work, and that's the sexy side of the case.
Right.
But it was also the side of the case that is not a winner, because you can always clean up a mess and get past the securities problem. The other side of the case that Howery and Simon in Washington were the backup on was the antitrust side of the case, which is the argument that if you put these two companies together, if the big fish eats the little fish and gets to be a bigger fish, it's going to kill competition in some line of commerce, or several different lines of commerce.
So lurking in the background of both of those avenues, you've got the Security Exchange Commission lurking, and then you've got essentially the Department of Justice also as well, correct?
Right.
Okay, so you've got two administrative agencies. Put a pinpoint in that for when we come back to that here towards the end.
Yeah, and that's exactly right. And then you've got a cast of characters. You've got two big law firms to do the backup work of finding out everything there is to find out that will fit into the securities problems. The other firm from Washington doing all the backup work, what you're going to find to do the antitrust issues. And then you've got the trial lawyers, which turned out to be two guys from Dayton, Ohio, who were going to try this case, which was a case to try to get the federal court to enjoin the proposed takeover on the ground that it would violate the antitrust laws if it happened. But let's talk a little bit first about the securities side, because that's the sexy side of the case, really, that didn't have to go to trial, but kicked up an awful lot of sand and a lot of interesting publicity. You know a little bit about that story, I think, don't you? So,
yeah.
Tell us what the story looks like.
Well, I believe we have a little bit about from Bill Gillum and yourself. Is that right?
Well, both of us. We were the point guys, the trial lawyers who were going to have to try these things.
Right.
Although the antitrust side was what actually went to trial. The securities was another set of issues. In those days, largely administrative law issues.
Right.
Before the Securities and Exchange Commission. But that's where all the exciting stuff turned out. Love Canal was discovered, the first big EPA mess in America. That was the doings of Occidental Petroleum.
Right.
There is a wonderful story about how Occidental Petroleum had acquired all the oil rights in one of the big countries in North Africa, and done it by giving the sheik who ran the company a lot of money.
Right.
And it was charged that, hey, that was a bribe, wasn't it? And it got tried in the British courts with a barrister who, with a very straight face, said, in England or even America, it might sound like a bribe, but that's the way they do business in that country, and there's nothing wrong with the way. If you're going to be in Rome, act like the Romans. If you're going to be in North Africa, act the way they act.
So we discussed that there was this offer that Occidental felt Mead and its shareholders could not refuse. And some might have thought it was a fair offer at the time, but Mead rejected it, as you said, and then came back with its massive counterattack. It turned to a strategy of public relations, digging into the history of Occidental, other government agencies to help and expose its skeletons. So they hired its accountants, its lawyers, investment bankers, law firms, which you mentioned, to do their counterattack and to go on the defensive. And this attack centered on the balance sheets of Occidental, trying to peer in behind the curtain of what's going on at the business, whether it be unethical business practices, tactics employed by Occidental. After about a 5-month, multi-million-dollar battle ensued, was done to fend off this attempted acquisition by Occidental. I couldn't imagine how much money that would be in today's dollars, but this was still late 1970s. So this, of course, touched off several federal and state investigations, business practices by Occidental and its CEO, Armand Hammer. I love saying that. I'm going to say that as many times as I can just because it's fun to say. So the SEC, Security Exchange Commission, scoured the prospectus after Mead raised several issues regarding questionable business practices. Mead then accuses Occidental of misdeeds ranging from blackmail, fraud, operating in international energy arena. The president of Occidental allegedly delivered $25 million non-interest loan to the government of Peru, where Occidental had value. I'm assuming oil and gas was located there. So this is getting even crazier. Occidental then eventually gets charged with an attempted cover-up of toxic waste. And again, you mentioned the Love Canal in upstate New York. So among the many suits brought by the SEC against Occidental, there was a conviction for making illegal campaign contributions to President Nixon's 1972 campaign made by Armand Hammer. This is getting really weird. And based off Occidental's acquisitions, Mead's top officers then realized that they would lose their livelihoods after the takeover, and fought to prevent the merger, save their jobs and their corporate structure. So that was kind of the fighting back from the Mead Corporation, which seems very, very, I don't know, kind of scary.
That's scary. It's a great movie.
Yeah, I was going to say, why has this not been made in a movie?
It should have been. And in fact, one of the things that actually came out that was of interest, at least to me, was that every executive at Occidental had, at the time he received his job, signed a letter of resignation that was complete, signed by him. I hereby resign. I waive any claims of any kind, blah, blah, blah. And it's addressed to Armand Hammer as the chairman of the board. And it's the only thing missing on the letter is a date. And it all goes into Armand Hammer's desk drawer. And indeed, at the end of this war, they were all taken out of the desk drawer. The dates were filled in, and all those people lost their jobs. But be that as it may, while all that Love Canal and the bribes and this, that, and the other thing were wonderful fun, they were not something that could not be fixed. You can clean Love Canal. You can straighten out criminal charges. things can be done so that they weren't game breakers.
Yeah.
The only game breaker and the subject of the lawsuit that ended up being filed and tried in Dayton was that it would violate the antitrust laws to put these two companies together because it would kill competition in a couple of different lines of commerce. So that's you've given us the background of all that. Let's kind of look at how the thing got put together, because there's a guy who deserves a good deal of recognition. Good friend of mine, got me into a lot of trouble. He came from Takeover, Nebraska, born in Takeover, Nebraska, of all places, not the biggest town in the world. The only other person I ever heard of from Takeover, Nebraska was Hoot Gibson, the Western movie star of the cowboy movies.
Don't know Hoot Gibson. I
That
know
was
Hoot
even back in
Gibson
the
now.
silent era of film, I think. The wheel horse, the guy in the middle of the thing, was house counsel for the Mead Corporation. His name was Jerry Rapp. Jerry, I don't think ever tried a case in his life. He came to Dayton because he married a girl from Dayton. He was, at that time, the only associate in the firm of Smith and Schnocky, which was Dayton's big law firm at the time. So everybody else in the firm was a partner in the firm, and there was little Jerry as the only associate. Claimed he learned about the law from the secretaries at that law firm. And then he became a great friend of Jim McSweeney, who was the chairman of the board of the Mead Corporation, and a great man, below the woods, old-time lumber and paper man. And so Jerry had an unusual talent. He was a funny guy, he was a people person, and he was a human switchboard. And he could get everybody into the role that that person was to play and keep it all in balance and keep everybody happy. So there was no inner fighting among anybody. The role that Bill Gillum and I played was simply the role of the guys who were going to try the case if the case had to be tried. All the rest of the stuff was stirred up by this army of other backup lawyers for us. So we had the golden moment. Bill Gillum, who unfortunately is no longer with us, he passed away, but he was from Virginia, came to Dayton after being with a big firm in Washington, was involved in the Reichs Federated case with us. And he and I were the two trial lawyers. And fortunately, we did get a little video of Bill before he died. You'll see that he is a true Virginian. Armistead was his first name, which takes you back to the Civil War general that was part of the famous last charge. And he tried a lot of cases, as did I, and he'll tell you what he thought about our trying this case.
Yeah, let's hear from Bill.
Let's move on to some of the other major cases in which you were involved in your career, which now is 50 years.
Well, you and I recall with still great detail the attempted takeover of Mead paper by Occidental. That to me was the probably the best of all possible experiences as a trial lawyer. All the things that were happening.
So we were flying in the Mead jet everywhere, had breakfast at home, flew there and ate dinner down at the top of the Mead Tower. It's a hell of a case.
You and I did all of the defense cases with the exception of the Justice Department, and we had a very favorable Justice Department young woman, Barbara, and it was just great. And we had a favorable court. I mean,
you and I were the only two trial lawyers in the game in the long trial that we had on the antitrust stuff. And the other thing that was great in my mind about that case, other than just it was a lawyer's dream to try it, was that we had a team that no matter what role they had was a happy, coherent team, all worked together, the team on the Occidental side were just at war with each other from day one.
Yeah, it was, and that was a remarkable experience. I've never had that quite the same, because I get a call from Joe Flung at Skadden-Arps, what are we doing? And I'd say, well, we're doing this. And I'd say, I'm sorry, David and I got to go to work. We got to do some stuff here. Okay, that's fine, because Skadden-Arps was supposed to be the great geniuses in the takeover scenario. And we had Harry Simon, and they were doing the antitrust theory, and they were taking depositions, and so they were loading the guns. And I ultimately ended up taking the deposition of Armand Hammer. And Armand Hammer, who had come out of Russia as a MD, then gotten in the oil business, and then managed to become the great explorer of oil in Venezuela and the Middle East and so forth, was a piece of work. When I took his deposition, he had flown in, gotten on his helicopter. He must have been 97, and I'm not kidding. And I have a whole stack of stuff in front of me, and it all shows that his name is on these documents. What it shows is that Occidental is drilling dry holes so that Colonel Gaddafi will believe that they are, in fact, trying to find oil. In fact, what they're doing is drilling dry holes on purpose so that they can extract all the oil that they've already found before he nationalizes them. And this is what's said in the documents. And I'm handing it to him, and he's saying, oh, no. Got it all wrong. And I'm saying, well, these are highly placed people. You pay them a lot of money. You read, well, what do they know? And he would tell me, I just came away from having dinner with the Queen and the Prince of England. And it went on like that. I mean, it just distracted me.
So that was the operation. The case finally comes to trial in front of Judge Rubin here in Dayton. The federal courthouse is kind of newly built at the time, and it goes to trial. The courthouse is packed. It's not packed because there are a lot of citizens that find antitrust an interesting subject. Mm-hmm. It's packed with lawyers from New York and Washington, right, who represent arbitrageurs who are betting on what the outcome is going to be. Mm-hmm. I'm sitting there thinking, wait a minute, I'm trying this case, and this room is full of lawyers that are only here to hear what happens and then go rush to a telephone and get somebody to make a bet on who's going to win and who's going to lose. And they're all making more money an hour than I'm making trying this fool thing. Right. And the one vivid memory I have is in that big courtroom, which was later Walter Rice's courtroom, and fresh new room at the time. And I'm up there with this army of lawyers in the gallery behind me, listening to what's going on. And I'm making the opening statement on behalf of the Mead Corporation. And as I look up at Judge Rubin and I hear this murmuring behind me, I look down, and there in the bay of this big courtroom, there is a cockroach that is quietly walking from one end of the courtroom to the other end of the courtroom on a nice diagonal path. And to that cockroach, this case meant absolutely nothing.
Not at all.
And I'm thinking, well, you need that to kind of put it all in perspective, because it's a matter of pride. But as Bill said, this was a teamwork effort where everybody was a member of a team that all worked harmoniously together. The other side didn't quite work so harmoniously. I don't think either of us ever ate either lunch or dinner at home. We ate in the boardroom of the Mead Corporation for a month or more. Yeah. When we weren't flying somewhere to take a deposition or do something to try to get part of the case going. And so it was a Herculean effort, but the most fun I think either of us ever had trying the case.
Wow. Yeah.
We had lots of funny little things that happened.
Yeah, gotcha. So how things ended up, essentially, there wasn't a hostile takeover, correct?
Judge Rubin entered an injunction and stopped it.
Yeah.
And I think after the second week of trial, I'll remember the Sunday of after the first week of trial, I'm sitting in the boardroom getting my stuff together for the next trip to court, and I'm summoned into the office, and there's the chairman of the board, Jim McSweeney, there's Warren Batts, who's the president of the company, and they want to know, are we going to win or are we going to lose? And I, like any lawyer, that's a question that is impossible to answer.
Right. Yeah.
You can be a bookie and give odds, but that's all you can do. But in those days of hostile takeovers, there were things like called porcupines. If you're a company that's got porcupine quills, nobody will touch you.
Yeah.
If you're about to lose, there are white knights out there that will come and bail you out and buy it for a different price. And are we going to win or are we going to lose? I don't know. So happily, we finished it up with another week of trial, and we won on the antitrust thing. That ended the game.
But you had to work pretty hard to make sure that didn't happen.
Yeah, but it was fun.
I bet. Sounds fun.
Hard work is fun. That's one of the things I think you learn in the practice of law.
Well, so like I said at the beginning, I was kind of like, well, how can we bring this full circle? And as we stated before, the Supreme Court of the United States threw us something that ties into kind of what we talked about. I did a little bit of research, and when we talk about the word liberty, particularly when it comes to the 14th Amendment and our Constitution, we're typically thinking physically, and due process rights and right to be heard and notice pleading and things of that nature. And the term liberty was, when it was kind of discussed in this case, Allgaier versus Louisiana. It was written by Justice Bradley in 1897. He described liberty, the liberty mentioned in the 14th Amendment, means not only the right of the citizen to be free from mere physical restraint of a person, as I just ended, but or incarceration as well. But the term liberty is deemed to embrace the right of the citizen to be free in the enjoyment of his faculties, to be free to use them in all ways, to live and to work where he or she will, to earn his livelihood by any lawful calling, to pursue any livelihood or vocation, and for the purpose to enter into all contracts which may be proper, necessary, and essential. So it starts talking about, the right to contract. You've got your employer, your employee, corporation, corporation, big fish, little fish comes into play. The Constitution, the Fifth Amendment discusses due process under law and had been interpreted to mean the federal government had to maintain fair procedures. So throughout this long period of time, a lot of things are happening that we're kind of hearing about today. The freedom to contract, and as well, we're hearing a lot about compete clauses and things like that. So one of the books that I finished reading, and I think you've read it, The Great Dissenter, if you get a chance, by Peter Canellos.
And every lawyer's hero, there he is, John Marshall.
Yeah, and for those who don't know, the book about John Marshall Harlan, who wrote the dissent in Plessy versus Ferguson, they're used to overturn or used for Brown versus Board of Education. Justice Thurgood Marshall took that dissent with him wherever he went. But he dissented in a case, Lochner versus New York. Now you say, well, what does Lochner versus New York have to do with anything? So there was this period, the Lochner era, where essentially this era becomes synonymous with judicial overreach as coined by many legal scholars. And the Lochner case is interesting. It's one of those cases that doesn't get enough attention, but it's so important. And it's essentially centered around this Baker Shop Act, which forbid bakers to work more than 60 hours a week or 10 days or 10 hours a day. Lochner was accused of allowing an employee to work more than 60 hours in a week by essentially giving him a piece of the pie by not calling him an employee, but making him somewhat a partial owner. So the first charge was $25, and the second $50, and then while he didn't challenge his first conviction, he appealed the second conviction And this goes all the way up to of course, the United States Supreme Court. What's interesting about this case is the court rules that contractual freedom could be curtailed only to protect public health or the health of the workers at risk, and that the act did not do so. That's important because now, at that time, the court is making the determination as to what is not considered or the intent to protect public health or the health of workers. Offshoots of that are your administrative agencies that become implemented in order to address the health and safety, the needs of communities. So at that time, what you're having is a court intervening and interpreting the intent of administrative statutes and whether or not their intended purposes were actually being accomplished. That's what the court was essentially doing at the time. Remember, this is a time where the New Deal programs are coming, and many of these New Deal programs are getting struck down during this Lochner era. Funded governmental jobs that created boards to determine fair wages, subsidize housing, and subsidize for farmers to reduce crops to sustain agricultural prices, minimum standards for child labor. I mean, we have the 40-hour work week essentially as an offshoot of that, and child labor laws and addressing poverty, homelessness, things of that nature. Even today, we still have the products from the New Deal, Social Security Administration, the SEC, which we talked about, we'll briefly touch on here, the FDIC, the National Elections, the NLRB, Relators Board. So more of a pro-laissez-faire, pro-business, let it be type of infrastructure. Justice Harlan at the time, in his decision in the Lochner case, stated that employers and employees in such bakery establishments were not on equal footing. The necessities of the latter compelled them to submit to such exactions as unduly taxed and taxing their strength. So we're going to move forward then, because there's a case that you and I both recall from law school that brings us to the Chevron case. And Dave, I got a quick question for you. The question is a simple question that you probably know, but should commercial fishing vessels be required to pay for compliance monitors? You know, these compliance monitors are essentially tools used to collect fishing data, the number of hours spent, and the amount of fish caught. So that's a simple question, right? That's not going to be a big deal. It's just a question about compliance monitors for fishermen, right? So it's not that big of a deal, is it?
One would think.
Well, all of a sudden, it just became a very, very big deal. So as we're, with the Chevron case, essentially, what do we do when a federal statute or a law is ambiguous or silent on its interpretation? And for 40 years, the Chevron case essentially allowed for Congress and federal agencies such as the EPA and other administrative agencies, which relied on the Chevron doctrine, entrusting them that they crafted stable statutory regulatory landscapes and pretty much laws that protected the Americans, and businesses know the rules of the road, right? So essentially allowing these administrative agencies who know the law of the land, the fishermen that know the constructs and the confines of that. And recently in Relentless Inc. versus the U.S. Department of Commerce and also Loper Bright Enterprises versus Raimondo, these pair of cases recently upended 40 years of administrative jurisprudence by shifting the power from the executive branch to the judicial branch in determining issues such as fair pay, working conditions, merger acquisitions, healthcare, clean water, financial markets. And I'm curious what Judge Rice, who was recently here to talk about the upending and the reversal of the Chevron case. People heard about this case and how it was upended, but the ramifications from it, we had the pleasure of hearing from Judge Rice, a federal judge from U.S. Ohio Southern District Court, who gave us a little bit about what his thoughts on the recent decision. Judge Rice, I have to get your thoughts on the recent decision from the Supreme Court reversing the Chevron case. Your thoughts?
Well, I think it's an absolutely disastrous decision. For 40 years, judges have been required to accept an agency determination of its rules and regulations if the judge feels that the agency interpretation is and was reasonable when promulgated. Now, Chevron deference is a thing of the past, and it will be up to the court in each individual case to decide what an agency rule or regulation means and come up with a reasonable interpretation of it. The problem is, speaking personally, I was a history major for a very good reason. I am not prepared by education or by experience to interpret scientific data, to read scientific treatises, to decide issues that for the last 40 years have been decided by experts in a particular field working for a particular agency. Now, the fact that it will be difficult for me doesn't mean that I can't learn to do this, but the learning curve will be very, very steep. I think courts will become backlogged. I think you will have, on one particular agency regulation, 25 different opinions rendered by judges across the country. And I think the American public will be less protected by these agencies than was the intent of the legislation when it was drafted.
So essentially, what Judge Rice, a legend here in the Dayton community and national, both locally and nationally, this decision gives administrative agencies, and the whole point, I should say, of the Chevron case was to give the tools necessary to run government effectively and avoid a flooding of litigation that would attempt to eliminate the government's ability to protect Americans from bad actors or looming threats as society grows more complex. And as Judge Rice just indicated, now he and essentially and myself are going to be thrust into that position to get caught up to speed on some of these practices and making those decisions, and typically in areas that we may or may not be very familiar with.
And I couldn't agree any more than anybody else could with what you and Judge Rice feel on that subject, which may be part of the reason that we guided the boat, to go back to the metaphor of the Chevron,
Right.
guided the boat out of the waters of the administrative agency issues
Right.
into a simple antitrust issue, which is a typical issue that's solved by expert testimony in a courtroom.
And point being, the decision makers, the deciders during this era, during 1978, you bring that case, a year from now, we potentially could have a completely different result.
Yeah, if you did it on the administrative agency side, that's
Right.
true.
Yeah.
And that was a good reason, or one of many reasons, why while all the security stuff we talked about, which is agency issues,
Right.
were not game breakers the way the antitrust issues were.
Yeah.
And that's what sent this case around the Chevron issue into a true judge decision issue of application of the antitrust laws, which proved to be the game breaker as opposed to a game maker.
Absolutely. Did you have what was one of the more stressful times during that period?
Well, your job as a trial lawyer is not to be stressed, it's to give stress. And I think one of the most pleasant thing about that case, trying it, was that we had it sharpened down to a focused issue for a court rather than waiting around in administrative agency problems, which, well, in those days especially, were for the administrative agencies to decide.
Yeah.
and to be part of a team that worked smoothly and in focus, as opposed to a team on the other side that was all over the place.
Right.
And everybody went that side. We all went away happy.
Mm-hmm.
They all went away mad, and all the executives at Occidental Petroleum turned in their letters to be dated and filed.
Yeah, I have to give a big shout out to my father-in-law, who was a part of a merger and acquisition of CBS and Westinghouse. He actually helped me prepare for some of this when it came to, we've talked about the hostile takeovers, and then we see a lot of merger and acquisitions. Twitter recently, AOL, Time Warner, Microsoft, Yahoo. We see these things that take place and they happen. We know somebody is refereeing these things or supposed to be refereeing these things. And now recently we might be changing who the referee is, I guess. So big shout out to my father-in-law, who has a little bit of knowledge on the merger and acquisition side. And you, of course, had the opportunity to be deep within the litigation side. So it's pretty cool to hear from both of you and learn a little bit from both of you.
Well, and you'd like to say that, and everybody lived happily ever after, but as in all corporate life and human life, things cycle around, and as you pointed out earlier, ultimately, Mead is itself the subject of an acquisition, and becomes part of Westvaco, which it could have picked up with pocket change back in the early days.
Right. Wow, good. Well, this was pretty. This was way more interesting than I had anticipated. Thank you all for tuning in and listening. Be sure to subscribe. Again, Retrial Podcast. You can go to daybar.org. Check out Dayton Bar Association. A lot of things happening with the Dayton Bar Association. On the next episode of Retrial Podcast, we'll learn of a lawsuit that prevented a monopoly of computerized legal research and turned Mead Data Central into LexisNexis. Again, this Dayton Bar Association and Dayton Bar Foundation project was funded in part by a grant from the Dayton Legal Heritage Foundation of the Dayton Foundation and by a grant from the Jack W. and Sally D. Eichelberger Foundation of the Dayton Foundation. Please, again, subscribe, like, comment, share. We're doing this because we're having a lot of fun. We love to educate this great city of Dayton here that we want to represent. Only good comments, though, because, again, if you make bad comments, then they should start their own podcast, and then we'll talk about their podcast. Just let us know what it is, and we'll have some comments for them, right?
Sounds fair.
That sounds fair to me.